Good evening, Makhija sir. Am I audible?
Yes, you are.
You are audible.
Yes, sir. Sir, around 250 participants have registered for this discussion so far. So, should we wait for 5-10 minutes or should we start on time?
Maybe you can wait for 5 minutes. I think let's do that.
Sure, sir.
Okay. Otherwise, starting in time is very important. So
Yes, sir. So then we will start at 4:35.
yeah, not later than that.
Okay, sure, sir. Thank you. Sir, it's 4:35. I think we should start.
Yeah, please go ahead.
Yes, sir. Good evening, Makhija sir, and all our participants. Welcome to all of you at today's roundtable discussion on proposed amendments in CIRP regulations and real estate related proposals. At ICSIRP, we always organize roundtable discussions through online mode so as to make more professionals to participate and deliberate on the discussion papers released by IBBI before the proposed changes came into force. As you all are aware that recently on 1st of November and on 6th of November, IBBI has floated two discussion papers. One is on proposed amendment in CIRP regulations, requesting participants to please mute your audio. Yeah. As you all are aware that recently on 1st of November and 6th of November, IBBI has floated two discussion papers. One is on proposed amendments in CIRP regulations, which aim to streamline the resolution process and prevent delays in implementation of resolution plan, wherein IBBI has suggested some 7 measures. Another discussion paper is on insolvency process related to real estate projects. These two discussion papers are open for public comments. To enlighten all of us with the proposed amendments and their technicalities, we have requested our distinguished speaker, Mr. Ashish Makhija, sir. Sir will also moderate this roundtable discussion to collect views from our participants. Sir does not need any introduction. Most of the professionals already know Ashish Makhija sir, but still I'm giving his brief introduction. Sir is
I think we can skip this part, so because we are aware, let's continue more time on discussion. Let's skip this part.
Sure, sir. Sir, requesting you to please deliberate on the discussion paper. Also, kindly moderate the discussion. Thank you.
Okay. Thank you. I think, friends, a very warm welcome and a very good evening. In fact, the Institute of Insolvency Professionals, IIP, has been at the forefront to organize such kind of programs, and we must appreciate their efforts towards this. And also, I think we must really appreciate the IBBI is the main regulator, that before making any changes, there are proposals which are circulated for discussion. I think that's also extremely important. Well, at times, some amendments are made even without discussion, but yes, most of the time, the discussion papers are floated and the comments are asked for. Friends, before I start the discussion, I'll tell you how we are going to go ahead and also the rules of this particular session. Before that, I think may I request everyone to please open your videos, because we want it to be not a faceless discussion, but we see each other and then the interaction is possible, because this is more interactive. Rather, I would request you to comment rather than me commenting on this. I'll just explain the proposal and then probably we'll have discussions. So how we are going to do it? I'm going to take, because there are two papers, so naturally the discussion will be a little longer. So therefore, please bear with me. There are 12 points, 7 in the CIRP discussion paper and 5 in the real estate. So we'll have to divide time accordingly so that everyone gets a chance to say. What I propose to do is that I'm going to just, share it on the screen, the discussion paper. We'll go point by point and we will invite comments point by point. First, I'll try to explain what was the background and why it has been introduced. And then also, if I have any comments, I'll make, and then I'll request the participants to make comments. But here there are two things. If you agree with the proposal, well, there's nothing to be said. If you agree with the proposal, but you want with modification, then naturally you need to be heard. Or if you are, say, dissenting or not agreeing with the proposal, naturally, again, we'll have to hear the reasons of it. So I think let's do it that way. If you agree, you can just simply write agree on the chat box, and I think we'll move further to the next one. But if you agree with modifications, then naturally you can write down in the chat box, unmute, and one by one, I will request the ICSI professionals the institute, peer is there. So she will unmute, and then of course we will move from there. So Peer, can you just put it on the screen, the first discussion paper, which is relating to CIRP, the corporate process, insolvency process. Okay, so friends, what is this all about? Now, it talks about 7 points, 7 issues which are there. The first issue, which is very important for all of us, is relates to approval of the COC for the insolvency resolution process cost. Well, I think while we have been working as the IRPs and RPs, we all know that we can incur expenditure and then go for the approval. In fact, we are not taking the approval, we are taking ratification, because at the end of the day, they have to ratify the entire expense, and only that expense is typically paid. But here, the IBBI wants, and in fact, you remember that regulation 30B was also introduced, where it talked about audit of expenses of the corporate debtor. So even that audit is also possible if one of the committee members wants it. So in any case, that was naturally a very good provision, because we do not want any finger to be raised on the IRPs or the RPs. Now here, the IBBI is clearly stating that, look, Pete, can you just go on to the next page on the top? I think we'll just show what is the proposed amendment. Yeah, go to the next page. Yeah, just here. So 31B is proposed to be added here, friends, which is on your screen. The insolvency professional shall place before the committee the operational status of the corporate debtor and shall seek approval for all the expenses, including the expenditure incurred in running the business of the corporate debtor as a going concern. So typically, if you go to the definition of the term insolvency resolution process costs, now there, the third item in section 5, subsection 13, clause 13, and then there is a clause C, that if you are incurring expenses on the CD as a going concern, that is also a part of the CIRP cost. But typically speaking, there was no specific provision that you have to take approval of that expenditure. So if I read this, it says the IP shall seek approval of all expenses, including the expenditure incurred. So here, if I devote my time on expenditure incurred, means that IP is entitled to incur that expenditure, but later on he can get the approval. But here there comes slight difficulty. Supposing you incur an expenditure and tomorrow it is not approved, then what is going to happen? So typically after this 31B, when it is introduced, my suggestion would be that if it is not possible to hold immediately a COC meeting and the expenditure has to be incurred for running the company as a going concern, naturally you will have to incur. But otherwise, I think IPs generally do prepare budgets also. They get it approved by the COC. Do that. I think that will be a better thing to do. So this is the proposal that 31B is supposed to be added. So if I'll just leave it open now for the participants. If you want to make any comments, but your comments should also be very brief. So because we have to go to the 12 points and I want absolutely brief discussions on that. So we can go one by one. I think Mr. Sharma had raised his hand. So Mr. Sharma, I think you can unmute and go ahead.
Sir, in case there is a genuine expense, which is even RP has to start incurring as the CIRP starts, like recruiting or seeking a legal consultant and other requirement, and COC suddenly comes up later and say that, no, I'm not approving it. Do you think it is right? Because it is RP's prerogative to have a counsel for CDM himself, and you have experienced that matter between us.
Okay.
So these should modify that COC cannot unreasonably, or wherever RP has to have an authority, they cannot.
Okay, I think I will answer it this way. I will look at it in this way, that look, in any case, the expenses required to be ratified even today. So supposing the COC does not ratify, then what is the recourse which is available? The recourse available is, naturally you approach the adjudicating authority and ask for the approval, and which typically is granted. I mean, I've seen in many cases that if unreasonably COC holds that approval, then they say, why are you holding that approval? the only point what I'm trying to convey is, if there is an emergent expense or urgent expense, naturally you will have to incur first and then go back to the COC. But in normal course, what I suggest is, because there are many experienced IPs are there, it is always better, because now another proposal is that every month there has to be a COC meeting. So naturally, you can always get the prior approval. Of course, the word prior approval is not written here. It says including the expenditure incurred. Incurred means you can incur the expense and go back. But we are only discussing the eventuality. If you incur the expense, if they don't approve it, then you are in trouble. So it is better to have the approval first, what you can anticipate. If you can't anticipate, naturally you will have to incur that expense. Okay, I think Mr. Brijesh Singh Baduria also has raised his hand. Yes, sir, please go ahead.
Sir, thank you very much for this opportunity. Sir, my concern in this case is that the RPs are typically being forced by the COC to accept the expenses as per their own wish, which is creating a lot of disconnect between the priorities of the RP and the priorities of the COC members. What
Okay,
I have
sir,
observed,
I'm just stopping it here. Can you elaborate on this? I mean, based on
Sir,
your practical experience, what
sir,
kind of expenditure has not been approved by COC, or they're restricting?
Yeah, sir, the live example I want to quote is that, for example, RP wants to pursue one case and appoint one lawyer. Then there is a fees, and the RP is, of course, sir, everything has to be subject to audit, and checks and balances should also be there. I'm not saying that day from stage first, RP should be intentions of RP should be doubted or something like that. I have personally faced, sir, there were some critical cases, and I propose that this lawyer should be engaged so that he can handle this matter. So the COC members persuaded and impressed upon me to accept the lawyer as per their own wish, and preferably from their panel.
Well, that is typically incorrect, because in any case, there have been cases where the valuer which is on the panel of the banks has been accepted, and that IP has been held guilty of
Yes,
professional
sir.
misconduct.
And sir, what happened that I had to change 2 lawyers of the COC members, and I had to convince that. But what happened in that case? The precious time lost.
Okay, we have understood. Now, please tell us. Now, look at
sir, this is very simple example I have quoted. Now, I will quote the examples where the RP has to run the business. Now, when the question of keeping the corporate debtor as a going concern is concerned, there it's a huge task, huge responsibility. So, sir, there has to be some mechanism, because here also the philosophy what I feel from IBBI is coming, that it has to be with the approval of the COC member. I accept that. But there has to be some mechanism also inbuilt. For example, sir, there has to be some mechanism in this where the RP.
Friends, may I request everyone to just please mute themselves, because we are in the discussion. Thank you so much. Yes, sir. Please.
So, sir, for example, RP has to run the business. He should present a budget maybe for 6 months. And then for 6 months, this should be approved by them. I did this in this case, but there was no approval from COC for such. One member stepped down and he said, no, I'm not going to approve the running business. You only put up for our noting. That's it. It's your responsibility.
No, but I think, you see, we can understand, because earlier those kind of provisions were not there. But with this provision, I think it will be incumbent upon them to approve it. So here, taking your point, I think we understand the concern. But do you think, supposing you prepare a budget and say, my legal expenses will be for next 6 months will be this much amount, right? Then the freedom to choose lawyer is on you. I mean, if they are restricting on the choice of the lawyer, that is little bit not a good thing, which I also agree. Because as far as professionals are concerned, you better know that, look, what type of a case is this, what type of a professional you require. But now looking at this 31B, what changes do you suggest? I mean, let's come to the brass tacks now. So do you want to suggest any changes on this, or you are okay with this, just with your concern that we should forward it to the IBBI, that look, for this is also the concern?
Sir, my proposal in this case, although I immediately cannot suggest the language, but
Okay.
what I want to say that there
Hmm.
has to be some liberty given to the RP to incur the expenses. Of course, that can be subject unless there is some deviation pointed out by the COC, some departure from the established practices, something like that is there. Unless that is there, RP should be given liberty to incur the expenses as far as going concern is concerned, as far as CIRP is concerned.
Okay, okay, understood. Okay. I think now we can move on to Mr. Bharat Sethi. Yes, sir. And I request everyone to be please very brief because we have 12 items to discuss.
Good
Yes, sir.
evening.
Go ahead.
Sir, my point is this issue is already covered in Regulation 31E. Indirectly, it is more or less it is covered, so there's no need for introducing the same.
So, in fact, in the discussion paper, you are right. In fact, they have mentioned that and they have referred to Regulation 34 also. And if you look at Regulation 34, it reads that committee shall fix the expenses to be incurred on or by the resolution professional, and the expenses shall constitute insolvency resolution process cost. So what you are referring is they are actually referring it to the whole aspect. I mean, this Regulation 34. But only thing is they have also considered that, but they say, look, if we go to the parts of the insolvency resolution process cost as per definition, right? So as per definition, clause number C, which it talks about CD as a going concern, they say COC has no role to play to approve it, to approve those expenses. So that is why they are wanting to fix that responsibility. That's all. So that is the whole idea about it.
Correct.
Okay. Yeah. Okay. I think now we can hear Manjula ma'am. Yes. Ma'am, we can't hear you. I think you are muted.
Sorry, sir.
Yeah,
Good evening, sir.
please go ahead.
Thank you for giving me the opportunity. Sir, this will hold good only when in my case, the COC members who were present in the meeting, especially when banks or the COC members, they were not able to take the decision. So they said they had to consult their managers. So in such cases, will this really hold good? That means COC must consist of members who can really take the decision and approve the expenditure. So that should
what you're fearing is that there will be a delay. Supposing if there is a delay, then naturally the process of going concern will also be delayed. Okay.
That is,
I think that's a good point. Yeah, that's a good point. I think we will note it down this and we'll convey this to IBPI. Yes.
yeah. Thank you, sir. Thank you.
Okay, great. Mr. Shah, Pinakin Shah. Okay. I think Mr. Tanveer Alam, you can speak because I believe Mr. Shah is not hearing us.
Yes, sir. Yes, sir. Good afternoon, sir.
Yeah, good afternoon.
Sir,
Yeah.
what I feel that, see, there's some sort of protection mechanism needs to be introduced for clarity purpose. Why? Because prior to, 30 days, when we, enter into CIRP and the first COC meeting happens, there are expenditure which has to be incurred by the IP to keep it as going concern. Security cost may be there, maybe the cost of the lawyers, verification of claims, and the rest of the issues. So there has to be some sort of protection given to those expenditures unless that expenditure is vitiated by fraud or maybe misconduct. The second aspect maybe then when we have a COC meeting and now we have proposed COC meeting every 30 days. So there may be some unplanned expenditure. For that also, some sort of protection mechanism must be introduced here, since we are clarifying on several aspects of insolvency process and the cost.
Okay, I think your point is well taken, but let me explain this. Like, if you incur expenses before the constitution of the COC, naturally you are an IRP. So those expenses are also part of the insolvency resolution process cost. And naturally, if there is no COC, no prior approval, no approval can be given. But these expenses are also ratified later on, isn't it? We already have a mechanism that these have to be ratified. And if they are not ratified, to that extent, will be paid by the applicant. So therefore, as far as IRP expenses are concerned, probably you are covered. We are only talking about, talking about the expenses which you are incurring as a going concern when you become an RP. So whether it should require approval or not, they are simply saying require. They are not saying prior approval. Let's understand this. They are also saying, because I emphasized on the word, including the expenditure incurred. So which means you can incur the expenditure and you can go back. But we are only discussing one eventuality, that you incur an expense and tomorrow they don't approve, then where do you land up? that will get you in some kind of a trouble. That is what we were discussing. But your point is well taken. That protection mechanism must be in place. Okay,
The whole idea that it should not be left to the whims and fancies of the COC.
Absolutely.
Because,
I think everyone is one is delay, one is not left to the fancies of the COC. I think your point is well taken, sir. Okay, I think Mr. Munish Sharma, yes, please go ahead, sir. Okay, I think Mr. Shah is also unmuted. Maybe after Munish Sharma ji, I think he can also speak. Yes.
Thank you, Ashish ji. My point is, you have been referring to 513C more than once in the discussion.
Right.
And by very definition, the cost incurred by ERP for running CIRP doesn't require approval of the COC. But by definition, it is a part of the CIRP cost.
Correct.
Now, 513E says that board can specify certain other costs. Now, while framing original regulations in 2016, board exactly had no idea that what costs are to be fixed for the RP to be approved by the COC. So they simply put a sentence that all expenses to be incurred by RP to be approved by the COC. So that was the case where the delegated legislation has been in a way exceeded. Now they are putting an icing over that thing. See, if you look at the 196(1)(t), the board can only make regulations for the items for which it is required to make regulations by the court. Now they are exceeding their jurisdiction. So in my humble submission, they do not have the legislative competence to, in first place, to make regulation 34, and now to add icing onto that already exceeded delegation.
Okay, I think your point will definitely be conveyed. We'll make a note of it, whether IBBI should also look into this, whether they have the legislative power or not. Okay, right. Okay, I think Mr. Shah, yes, please, sir, go ahead.
Yeah, as far as this expenditure incurred to keep the organization as a going concern, my experience is that because I've handled a assignment involving about 7,500 crore when the factory was working at 90%, and I put all the expenditure for the approval of the COC, but at the same time, immediate reaction was that we are not competent enough to analyze whether these expenditures are required to run as a going concern or not, because this does not involve the expenditure for professional fees. It is a purchase, sales, and lot many expenditure incidental to keep the organizer going concern. So I welcome this suggestion, no doubt, but whether COC, how they are going to take it and how IBBI will implement through COC, that is going to be a major concern.
Correct. I think your point is also well taken. In fact, you are supplementing the views of the previous participants also, that there will be a delay. You are raised the issue of competence. I think that's a very good point. We will make a note of it. And because you see, the point what you're trying to say is that, look, if the COC members are there, they, as in your case, they said, look, we are not competent. What kind of expenses you are incurring, whether it is right or wrong, it is your responsibility to incur. So here, the onus is now coming back on COC now to approve those expenses. So I think your point is taken, sir, and we will make a note of it. Yes, I think Mr. Prasad, yes, Mr. Sivarama Prasad.
Yes, sir. Yeah, actually here the rights are given to COC and the obligations are given to IP, right, to approve expenditure, whereas it is the obligation of the RP to appoint registered valuers to see the computer data in a running condition, going in a going concern. So he is having no obligations, they are having the rights, that if there is a conflict, there must be somewhere saying that, to bail out the RP from the situation.
Okay.
He has got obligations, whereas they have the rights. So where if there is a conflict, what RP should do?
Okay, I think again we are coming back to the same thing, that look, in any case, to keep the company as a going concern, yes, I need to incur that expense. But what happens if they don't approve it? Then where I'm going to land on this? And since it is my obligation, and it is my duty rather to keep the company as a going concern, And if it is not approved later on, then what is going to happen? So I think that's raises a question mark. I think we will definitely put it across. Okay, I think anyone who is left out, I think Mr. Rajesh Bakshi has also raised his hand. Sir, can you just be very quick, because I think let's move on to the next.
Suggest the language should be unless until objected by the COC, the expenses presented should be deemed to be approved.
Acha, okay. So you are saying let it not be an explicit approval, because you see the discussion paper uses the word there has to be an explicit approval by the COC. What you are saying is putting the onus on them that whatever is put in, well, if you don't object, it is deemed as approved. This is what you are trying to say, sir? Okay, let's see how that cuts ice with the IBBI.
One thing I would like to add.
Yeah.
Sir, let there be a time frame within which once approved it is cleared. And if they are not clearing it, let them give the reasons behind it so that we can take an appropriate action.
Sir, I think let's not get into that, because I'll tell you the problem. Earlier, there was a provision that IP can be replaced by the COC. We have a provision that, and then many of the IPs at that initial stages, they said COC cannot do it unless they give reasons. I was the one who opposed. I said, don't ask for reasons, because they will write 10 things against you, that you are incompetent. Do you want that to be recorded? So I think let's not get into the, because once they record, then they will not be able to go back anytime. So I think whether it is approved, not approved, that's fine. And if it is not approved, then the recourse is, if the expenses are naturally genuine, you have got it audited, I think AA will support you. That's my opinion. Let's not get into the reason part of it, because I can write English and I can write 10 sentences against you and against that expense. Then it will be very difficult to cross that bridge.
Correct.
Okay. Okay. I think friends.
Makhija sir, good evening. I am not, somehow my actually system is not supporting me to raise my hand.
No problem, sir. Go ahead.
Sir, there is a very peculiar kind of situation where the COC consists of only operational creditor, representing government departments. So it has happened in one of my colleagues' case, like wherein government department are the only constituents of the COC member, wherein they're just for their sake of they are not coming to the COC, they are not ready to contribute to the CIRP cost. So these all sort of problems are there. When they are being asked to explain, they say that okay, we are here just for recovery and we are not concerned with anything.
Okay.
So how to tackle?
Yes, I think we have understood. You see, these problems have come in many cases, but here, you see, the issue here, what we are discussing is different than what you are trying to raise.
Yes.
I understand that there will be OCs only, sometimes not only government, but there may be only private claimants could also be there, and they may not be in a position to approve anything, because ultimately they don't want to pay any money out of their pocket, and we have faced that problem in few cases. But at the end of the day, in that case, you will have to approach the AA to ask for payment of those expenses, and two, if the company is going towards liquidation, then probably you will have to move an application if there is no cooperation from them. But that will not be a part of this kind of a discussion out here. Okay. But anyway,
Makhija ji, what is your opinion on this? What is your concluding opinion on this?
Okay, see, all I'm saying is my conclusion is that, look, as far as the approval of the COC is concerned, we are indirectly taking it because we are getting a ratification, isn't it? So this also seems to be a similar kind of a thing, because they are not asking for prior approval. But only I'm suggesting that after this proposal comes, this provision comes, then naturally you will have to take steps to get the prior approval so that you are always on the safe side. But it may slow down the process of CIRP, I don't know. But if you are holding meetings regularly, I don't think that should be a problem. So I'm in favor of this kind of a proposal, that let it go. But yes, your concerns which have been raised by the participants, I think they are also very important and they should be brought into, so that a mechanism can also be looked into. Okay.
Yeah, if you read at the objective of this very much addition, they talk about to streamline the process and improve the monitoring of the COC. So whether COC would also like to monitor, then how the monitoring go with the approval? Because if they want to do the monitoring, when the item comes for noting also, see what is the practice. All the running expenditures, and if you go to the COC for approval, factory will be shut down. Let me tell you, it is going to create such a problem. Because for everything, they have their own mechanism within the banks to get the approval. and sometimes the corporate action cannot be held up for such a period of time. Second, sir, how the monitoring talk about when the approval has been done on monthly basis, you present before the COC all kind of the expenditure, two kind of expenditure. One is the CRP related expenditure, direct expenditure, what you say, and another set of expenditure is called running business expenditure. So usually running business expenditures are also placed before the COC in detail, everything. Whenever they have any observation, they can ask why this expenditure has taken place. If the expenditure is putting any kind of the CRP cost on their head, or it is making their cash flow negative, they can go into the detail. Further, CRP guidelines have given them the audit authority. So
okay, no, Mr. Chaudhary, I think
how this provision is valid to that extent, sir?
Yeah. Just let's try to understand. See, the point what you are raising is that it is very restrictive. See, the point is, supposing you incur an expense. Today you have incurred an expense, and tomorrow they don't, because you need ratification, isn't it?
Yes, sir.
Because as per regulation 34, they can also put restrictive conditions. They may not approve it. Then you will land in trouble in any case. So how it is going to make a difference to that? I'm not really able to understand that. In any case, today, supposing in a monitoring.
I'm not saying, sir, COC has any authority to approve, sir. It is the RP who have to run the business operation, or we have to amend the law. We have to, the COC and RP are under the obligation to run the business, sir. And we have to amend the law.
No. I think let's not get into. We are getting too much of. You see, we are reading too much into this. It is not like this. Please understand. All it is saying is that, look, there was no specific clause to get their approval. It was only indirect way that they need to ratify it. So now they are saying, let them approve it. So let them approve that first, not first, but you are still entitled to incur that expenditure, and you can get an approval later on. So naturally, there is no difference between. So what I'm suggesting, the steps are: A, now we are all experienced IPs. So whenever we take a CIRP case, let us prepare a budget. And in the first meeting itself, let's put the budget that these are going to be the expenditure for running the company and for other expenses. So naturally, they will have to approve the budget or disapprove it. So therefore, the discussion will take place in that first meeting itself. So you will be relieved of this. Second, the audit. See, I must tell you, in one of our cases, the person got the audit done, and audit expenses were also part of the CIRP expense. IBBI sent a notice, show cause notice to the person that how can you charge audit expenses as CIRP expenses? If you want to get it audited, you pay from your own pocket. Then when I represented that person before the IBBI disciplinary proceeding, I explained, sir, this provision should be there in IBBI, in your regulations itself. Because tomorrow the fingers are raised, so audit means the skin of the IP saved. So, and then they brought that provision in the form of 30B, you know that, you see, though that was added later on. So get the budget approved and get the audit done so that you are absolutely in the clear, so that you don't give any chance to disapprove any expenditure to COC. So whether monitoring or approval, I don't think there is any difference in both the things. So that is what I said. I support that. Yes, it will be restrictive because, you see, as members raise the point that, look, there can be a delay. The people are not competent to approve it. They may say, okay, defer it to the next meeting. That is a possibility which we are anticipating. So that could be a problem. Okay. I think your point is taken. We have heard you. So definitely those will be forming part of the submissions to IBBI. Okay, I think let's move on to the next point, because I think we have devoted a lot of time on this.
Sir, one suggestion.
Ashish ji, may I for just 30 seconds?
Yeah. Just please go ahead.
Yeah, thank you. I have a couple of suggestions on this. I mean, it's a welcome provision. One is that because the intention is at the same time is the COC can be monitored. It can be done provided there is an additional clause to it. If the COC is rejecting this proposal for approval, there has to be a written reason that why they are rejecting it. So the duty has been casted on the COC being responsible, that why is that? That will help even RP to move before the adjudicating authority. Second is in case if there is a delay, because there is a system of having a e-voting. So if there is too much of a delay or they are asking for an extension, then this provision also can have an additional clause saying that in so many number of days, if it is not approved or rejected, it can be considered as a deemed approval.
Okay, so time frame should be added, as I think one of our participants. So I think that's a good suggestion. That
Sir, one suggestion, sir, please.
Yeah, please.
So the COC creator must be mandated to have a qualified authority, dedicated authority to deal with these matters, insolvency matters.
I think,
So that
sir, we have discussed this on a number of occasions, and IBBI is also conscious of that fact. But at the end of the day, the problem is IBBI does not control the COC. I mean, they can't control the financial institutions. So that problem has been taken up at multiple levels, even at the RBI level also. I think something is going to come. They are trying to put some officers who can take decisions on the spot. But the point is, this is an organization, large organization like SBI or any other bank. No one wants to take a decision on their own head. So that problem will definitely be there. It will be sorted out over a period of time. I think things have been better what we started in 2016. So I think let's move forward. I think these are good suggestions we have noted down. So now the next point, the next suggestion is that monthly COC meetings. I don't think there should be any difficulty in holding a regular meeting, because in fact, if you look at the paper, it says that in one of the cases, there was a gap of more than 6 months. In fact, on this case also, a show cause notice was issued to the RP, and I defended the RP. I said, your provisions don't talk about that there has to be a regular meeting. So if it's a small company, no meetings are required. So why should I hold the COC meetings every month? But let me also share with you that it is always what we call it as good governance practice to hold these COC meetings every month. So this is very important. But only thing is, Peter, can you just show the proposal? Just show the language of the, just scroll it a bit.
Yes.
Yeah, here. So 18.1, what they are saying is a resolution professional may convene a meeting of the committee as and when he considers necessary. This was already a part of 18.1. Now they're adding, and not more than 30 days should elapse between the date of one meeting and that of the next meeting. Well, friends, I have only slight suggestion as far as the legal point of view is concerned. Supposing I hold a meeting on 1st of October. So the next meeting has to be held on 31st October, because the 30 days elapse. Because if I hold it on 1st November, 30 days will elapse. So here in October, I'm holding 2 meetings. And then in November, again, I have to hold another meeting. So I think rather than saying 30 days, I think we can have it that one calendar month, one meeting should be held in every calendar month. So if I hold one meeting on, say, 1st October, the other I hold on 30th November, it should be good. I think no one should have an objection. So do you agree with this, or do you want some changes to happen in this proposed regulation? Any
I
comments?
have a suggestion here.
Yeah.
With your permission. Yeah, thank you. Here, the provision, again, I say it's a good provision. Provided there are many assignments wherein the corporate debtor does not have operations, number one. Number two is sometimes even after submission of a resolution plan before the adjudicating authority, there is not too much of a requirement to hold the COC on a frequent basis. So probably in my view, one can put up a provision the way we have for reducing the number of days for calling the COC meetings. The notice, what I'm talking about, the 5 days, say 24 days, 24 hours. Similarly, here also the COC can be empowered, saying that this can be extended from 30 days to 60 days, or whatever number of days, based on the nature of the operations or the conditions of the corporate debtor. Because this is something which is otherwise will make for all the types of corporate debtor to hold the COC meeting. That will be unnecessary thing, and it will add a cost, and there will not be much of a topic even to discuss.
Yeah, Rekha, now let me ask you, supposing it's a small company, whether we need to hold a physical meeting, we can have a virtual meeting, which is practically zero cost.
Yes.
Which is practically zero cost also, isn't it?
Yeah.
So
yes.
See, I'll tell you, because what I always suggest is that let's be on the right foot. Even holding regular meetings, in fact, in larger companies, probably you may require 2 meetings in a month also. So that could also be possible. But here, what the IBBI is saying is that, look, the status must be updated to the COC on a regular basis. So therefore, and that only way is to hold a meeting. In smaller companies, yes, we understand. So what we can suggest to IBBI is that this number of days option can be left to the wisdom of the COC. That's what you are trying to say?
Yes, of course. Yeah,
Okay.
that's right.
Okay,
Yeah.
okay. Your
Thank you.
point is taken. We'll definitely convey. Yes, friends. Anyone who has a comment, maybe. Because
I have something to say over here, Ashish ji.
Yeah, please.
आशीष जी, यहाँ पर मेरा सजेशन ये है कि सर सीओसी जहाँ फाइनेंशियल क्रेडिटर्स है वहां तो कोई इशू नहीं है सर, लेकिन जहाँ ऑपरेशनल क्रेडिटर्स है और ऑपरेशनल कंपनी नहीं है वहां पर 1 मंथ के अंदर मीटिंग थोड़ा सा डिफिकल्ट हो जाएगा। दूसरा मेरा कंसर्न ये है कि सर रिजोल्यूशन प्लान अप्रूवल तक तो मंथली मीटिंग ठीक है, लेकिन प्लान जब सीओसी ने अप्रूव कर दिया और एनसीएलटी में अगर पेंडिंग है तो वहां पर मंथली मीटिंग की रिक्वायरमेंट थोड़ा हार्डशिप हो जाएगा।
Correct. In fact, this was my next issue, which I was going to raise, that there is no clarity as to what happens if the plan is approved and it is pending before NCLT, because now it says the COC meeting can be held. So should that meeting has to be held every month, because it may not serve any purpose if the company is not a going concern. If it's a going concern, yes, it will serve the purpose, but otherwise it may not do that.
और दूसरा
So leaving it to the
wisdom अगर मेरी सीओसी में ऑपरेशनल कैरेक्टर अगर बैठे हुए हैं आशीष जी, तो मेरे को डिफिकल्टी वहां पर ये होती है कि सर ऑपरेशनल कैरेक्टर की सीओसी के अंदर एक एक एक्सपेंस अप्रूव बड़े मुश्किल से होता है सर। अब यहाँ पर फिजिकल वो आएंगे नहीं, वीसी पे करेंगे तो अल्टीमेटली देयर विल बी नो डाउट।
Sir, एक मिनट, just let me explain this. See, this is not going to solve your problem, because अगर आप मीटिंग 3 महीने में एक बार कर रहे हैं तो अप्रूवल की प्रॉब्लम तो तब भी रहेगी. So it is not that it is going to solve your problem कि भाई 3 महीने में मीटिंग हो तो then the problem is going to be solved. The only idea is, because you see what the IBPI thinks. Look at from the regulator's point of view. They say, look, you are controlling the company, you are running it, but COC is in dark, and for 6 months, in one of the case, 6 महीने तक meeting नहीं हुआ. So therefore they say, look, we are putting that requirement, but if we leave it to the wisdom of the COC, that whether they want meeting every month, every 2 months, or every 3 months, I think that's a good suggestion.
That will be a good. यहाँ पर ऐसा भी हो सकता है आशीष जी कि यहाँ पर एक सीओसी की विजडम पे जैसे नोटिस ऑफ लेंथ है, जहाँ आईबीआई प्रिस्क्राइब किया हुआ है कि मिनिमम 5 डेज का नोटिस है।
फ्रीक्वेंसी ऑफ मीटिंग भी उन्हीं के ऊपर छोड़ देना चाहिए। दिस इज व्हाट
वहां पे मिनिमम और मैक्सिमम टाइम प्रिस्क्राइब कर दें कि मिनिमम 1 मंथ, मैक्सिमम 3 मंथ्स।
Yes, minimum maximum period should be there. And another thing, sir.
I think, sir, one by one, let's not speak over another. Sir, so let's go one by one, sir. Yes, sir.
Can I?
Yeah, please go ahead. Please say your name and then go ahead.
I'm Ranjan Chakraborty. I'm saying that COC has the habit to postpone meeting, and sometime if the meeting would be convened in monthly in 30 days gap, they would keep on postponing it, and the meeting may go on. Actually, the meeting may go on for another 15 days or 20 days. So in that case,
sir, let's see. That can happen in every monthly meeting or 3 months meeting also. Then let's not discuss those things today.
So there would be, yes, minimum and maximum period should be there, I think.
No, maximum. Okay, so you are saying minimum should be 1 month and maximum should be 3 months. That's something like that.
Yes, sir.
So what is the maximum period you are suggesting? 60 days, 90 days?
That is 60 or 90 days. 90 days should be there, I think.
Okay, so let us leave it at the wisdom of the school.
From regulator's perspective, I am Deepak Garg, sir. From regulator perspective, after the expiry of 180 days, we file the CIRP 7 that the approval of COC is received with respect to resolution plan and it is pending with the adjudicating authority. Every month we file the CIRP 7 to that effect. So in that case also, we may not be required to hold a COC meeting, sir.
Actually, sir, see, the point is, look, you may be filing regular status report or progress reports with the NCLT also, right? Which I suggest that after every COC meeting, you must file. Some people are filing regularly, some are not filing even anyone. Today, they want to create a system that COC should not be in dark. So let's discuss the time period. I think most of the people have suggested that there should be a flexibility given to the COC where minimum period could be 30 days, maximum could be 90 days. I think that's a good suggestion to go ahead with it. So do you agree with that?
Mr. Makhija, this is Amarendran, and thanks for defending me in that case.
I never wanted to disclose your name.
No, it's okay. It's okay. It's all on the portal. But I just have one thing. There should be clarity on the fact that once the resolution plan is submitted to NCLT and there are ongoing hearings, and that took nearly a year for me. Yes, there's still a case for having meetings. But when the order gets reserved, now it's 3 months, and they are already told they're going to do a liquidation. Funds are pretty tight, and you can't even pay the AR. Then having a meeting every month is a bit of a stretch, you know.
But you see, look, those problems are there, that the funds are limited, but at the end of the day, who is going to contribute for the COC expenses or the CIRP expenses? Naturally, we expect COC members to contribute. They may or may not pay it. That's a different issue. Two, and in any case, if that is added up, naturally it will be taken out of the liquidation, whatever you are selling realization only. So I think expense part being, according to me, hold a virtual meeting, there are no expenses. So let's not talk about.
No, sir. There is expenses for the AR, e-voting, etc.
In case of real estate people, yes, that's an additional.
I'm
expense.
talking about that, sir. When you have hundreds of real, it's not very easy holding a meeting every month when there's no operations also. And the court has already told orally that we're going to pass liquidation orders, and that is taking another 3-4 months. You know?
So therefore, two things. Number one, regular meetings should be held till the time the plan is approved or the company is sent to liquidation.
Correct.
But once that application is filed before the adjudicating authority, then there should be a relaxation in holding the COC meeting unless the company is a going concern.
Absolutely.
Okay, got that. Okay.
Makhija ji.
Yes, sir.
I have a very basic question. Is that should IPs be spoon-fed like this and making laws, regulation more prescriptive, or it should be on principles and value-based? The reason why I'm telling is that as it is, the law provides that the RP may call for meetings whenever he requires, number one. Number two, if COC requires RP to call the meeting, he can call. So should it be so prescriptive that it should be within 30 days, 60 days, 90 days? So
I think
the point I am driving is more basic, is that should the law be too much prescriptive, going on too much prescriptive, or it should be more principle based? I mean, the point I'm driving it is in some ways undermining the capabilities of the IPs and RPs, more so because they find some DC cases, a few people are going out of the way. It is there, the black sheep are there in every field. So we can't be finding a solution for each and every small thing. I mean, this is my humble
I think Mr. Ravindra Belud, see, there is I agree with your word when you use prescriptive. That is all right, but it is not casting any doubt on this thing. Rather, what they are trying to streamline, because the objections have come from the bankers to IBBI that, look, we are in dark, the COC meetings are not being held for 2 months altogether or 3 months altogether. So therefore, this is a kind of a provision. And in fact, look, we are trying to standardize many things. If you are a company secretary, you know how many secretarial standards are being issued, and everything, you see, everything is being regulated. So I don't think there is any harm in holding this, but yes, there should be certain flexibility to the COC as far as the approval for the holding of the COC meetings. Your point is taken, sir. Okay.
Sir,
thank you.
Sir, another point. Sir, another point.
Yeah. Sir, can we be very brief now, because we have to move on to we are only on the second point right
now. The
minimum
period may be minimized as per discretion of RP, because whenever any urgent situation would arise.
No, that is still there, sir. No, please read this provision. It says a resolution professional may convene a meeting as and when he considers necessary. So you can always convene more meetings than what is required. But it says not more than 30 days should elapse between one meeting and the next meeting.
I have a small suggestion, Ashish ji.
Yeah.
Can we suggest one meeting per calendar month and not more than 40 or 45 days between two meetings? I say one meeting per calendar month and with not more than 40 days or 45 days between two meetings.
Sir, if we say 1 calendar month, it is good enough. So, because please understand, if it is 1st November and 30th December, how does it make a difference? You're holding a meeting every month, calendar month. So 45 days or 60 days, why? Again, you see, again, the question of being very, very prescriptive, isn't it? That's what our friends are. They say, let's give flexibility. So I'm trying to say that, look, 30 days is very, very restrictive in the sense that if I hold meeting on 1st November, then I have to hold on 30th November. Or sorry, 1st October, then 31st October. Now that, and then again in November, I'll have to hold another meeting. So within a span of 2 months, I have to hold 3 meetings. So this provision is little confusing to that extent. So that is why I wanted calendar month. Okay.
So one aspect, sir.
Sir, this is Nir Alam. I fully agree with you, and the whole objective of the amendment and the clarity which it brings must be understood by us. So, to my understanding, it brings more transparency and accountability, and it aims to invite more participation from the COC members. It's
Yes,
a welcome.
it inculcates
welcome
responsibility on
amendment.
them that they will have to attend every month and then they will have to take decisions in every month. I think that's also important. Yes.
It's very important. So I go with your suggestion, sir, that it should be every month.
Correct.
You know,
Calendar month.
And the difficulty which our fellow participants have suggested that is for regular thing like we transact in the company. So whatever board meeting we do, so if there is no business to transact, we can have a meeting that would be just a paper meeting and we could just file it.
True.
So there is no business
Absolutely.
to transact. That would become just a procedural thing.
Absolutely. Absolutely.
So one aspect I would like to share.
Hello.
Yes, sir.
Sir.
Please go ahead very quickly, sir. We have to move to the next point now.
Sir, I am Sudhakar from Hyderabad, sir.
Yeah, please go ahead.
Small clarification, sir, not related to CIRP. Just I want to know about COC meetings in the case of personal guarantee cases. The financial creditors, bankers are asking to conduct COC meetings, sir, without submission.
I think, sir, that let's leave it for another forum, or you can speak to me offline. Let's not.
Okay, sir. Just only because COC meetings has come. That's why.
I know. I understand that, but let's
bankers
not.
are asking to conduct COC meetings, sir, without getting planned.
I think we'll organize another program.
Sir, one aspect to be kept in mind is the time required to prepare for a meeting and to conduct a meeting. Because meeting may be for 2 hours, but how much time is required to prepare for the meeting? That is one aspect.
I think this is more secretarial in nature and it becomes more standardized, isn't it, sir? You have already kept a person. Obviously, it adds to the workload. So therefore, what we are suggesting is that let it be at the. That's all right, sir. That's all right.
But one suggestion, sir. One suggestion.
Yeah.
The meeting may not be conducted within the 30 days with the consent of the majority of the COC. If they concur, meeting, if it is not required, it may be.
Majority here, you mean, is more than 50%. That's what you're saying?
Maybe 50%, 60%, whatsoever is decided.
No, there is a difference, sir. 51% and 66%, there is a difference. So do you want 66% or do you want 51%?
Let it be 66%. It's more durable.
Okay. All right. Okay. I think let's move forward to the next point. We have discussed, I think, substantially out here.
Sir, can you please conclude this? What actually?
The conclusion is number one, that look, 30 days time period is very restrictive. So it can be 1 calendar month. Number one. Number two, the flexibility should also be given to COC. That if COC says, okay, if you hold a meeting once in a calendar month or once in 2 months or once in 3 months, and so therefore a maximum period of 90 days can also be put in so that the flexibility is with the COC. Because depending upon the nature of the business, supposing if the company is a small company, well, 1 meeting in every quarter is also sufficient, could be sufficient. So that is what the conclusion is there. And thirdly, the clarity is required where the plan is approved by the COC. It is pending for adjudication before the adjudicating authority. Do we need to hold a meeting every month under this provision, or there will be some flexibility to that extent? Okay, so this is the conclusion, sir.
And not and 90. The time gap between 2 meetings should not exceed 90 days.
That flexibility, yes, not exceeding 90 days. That is what the people have suggested. Okay. Okay, so let's go to the third point, disclosure of fair value in the information memorandum. Now, here, in fact, if you look at the discussion which is there in the paper itself, and I will like to read para number 2. Okay. Sorry. I think we are on point C. Sorry, I'm so sorry. Discussion of valuation methodology and report with the COC. Now here, what the IBBI wants it, I think I found it little confusing. So therefore, I think we need to really give our comments here. What is the proposal? Let's read the proposal first. It says, it is proposed that before finalization of the valuation report, valuers shall explain the valuation methodology to the members of the committee in a meeting facilitated by the RP. Now, this is what the proposal is. But if we look at the background, now what is the background? Look at the first sentence. The current CIRP regulations specify that the valuation report be disseminated to the COC only after reception of the resolution plans. Consequently, until this juncture, the COC possesses a restricted understanding of pivotal valuations, namely the fair value and liquidation value. The unavailability of the information constrains the COC decisions regarding the eligibility criteria for PRAs and the evaluation metrics, basing them on limited information. Now, this is what the problem which has been mentioned out here. But when it comes to the proposal and the proposed amendment, I think there is some confusion, because here what the IBBI is trying to say is that COC is in dark about the fair value and the liquidation value. Therefore, they can't take important decisions relating to eligibility criteria of PRAs and evaluation metrics, because they don't know what are the values. But when it comes to proposal, they say valuation methodology should be explained to them. So here, if you look at the proposal, can you just scroll, Pete? Yeah. So, no, just scroll up. Yeah, the two proposed, two registered valuers, and this provision is already there. They are adding a proviso. Provided that the registered valuer shall explain the valuation methodology to the members of the committee in a meeting facilitated by the RP before computation of the estimates. So here, the value is not being disclosed. Neither the fair value nor the liquidation value. What the valuation will come here in the meeting, and you will explain that, look, I am using this valuation methodology. That is, I'm using these methods. Now, number one, my question is, in fact, I do not want this provision to be here at all. That's if you ask my suggestion. Why? The reasons are very simple. Number one, you are giving a task of valuation to a professional. He knows his job best. Under what circumstances, what valuation methodology, because it says he has to do it in accordance with internationally accepted valuation standards. Now, supposing I'm a valuer and I explain that I'm going to use this method, COC says, sorry, don't use this, use only this. Now, will the valuer agree with the COC? Or will the valuer say, sorry, I will follow my international accepted valuation standards? I think there is going to be some kind of a problem. So explaining means what? I mean, whether it is after explanation, supposing they don't agree, then what happens? So I think this is something which is unnecessary. If they were talking about disclosing the value to them even before the approval of the receipt of the resolution plan, then it was a different matter altogether. But they were discussing something in the paper, and when it comes to the proposed amendment, this is something totally different. So I leave it on the forum to discuss and debate on this. Yes, sir. Any comments on this? And those who are valuers, also, IPs also, I think they will be in a better position to comment.
This
Yes,
would greatly compromise the independence of the valuer. It should not be there at all. I strongly oppose.
Okay, so you're saying that it will
it compromises the independence of valuer.
Okay, all right.
Yes.
Okay. Any other comments?
Makhijaji, I fully endorse Munishji's comment, but independence of the valuer would be compromised, and there is no need for him to discuss with COC until he gives the report. After the report is given, if they want clarification, that is a different issue. So this,
no, but sir, just listen to me. If he gives a report, that will also include the value. Now,
Yes.
our regulations do not permit right now that the value, because still that provision is still there, that look, the value should be disclosed only after the receipt of the resolution plan.
Correct. Exactly. I agree.
So therefore, giving a valuation report is not the idea here. They are only saying you must explain the valuation methodology. That's all.
No, it is not. It is highly inappropriate because you are essentially interfering with the functioning of an independent professional. That is how I would view it.
On the one hand, COC says we are not experts, we are not going to approve your expenses for the CIRP, and on the other hand, now they're interfering in the valuation.
Yes.
So there is a slight dichotomy in the paper itself. Okay, I think let's hear from others also. I think also raised. Yeah.
Also, if I may add, that the COC wants to control the valuation that they are going to get. So, it is not about being a third-party fair valuation. We will have vested valuation figures coming out, which is not what the board has envisaged.
So it is not a fair provision at all.
Yes, sir. Because I mean, the COC did, and as far as the figures go, I mean, the people are intelligent enough to come out with what figure the valuer is having in mind.
And what is the purpose of having a valuer then? See, the point is a valuer is a competent person, isn't it?
Yeah.
So I think we are all objecting to this. Yes. Any other views? One by one, sir.
Sir, good evening, sir. Ravichandran
Good
here.
evening. Yeah. Go ahead, sir.
Yeah, I am also a registered valuer. There are three approaches. One is income approach, market approach, and cost approach.
Correct.
So income approach and market approach, they are not applicable. Nobody is applying for a CIRP company.
Correct.
Because income approach, you require projections and other things. Market approach, you can't compare another similar company with this one and value that. So most of them adopt only one method, cost method actually. So when there is a case, then it is, what is that they are going to explain about that method? I'm not sure actually. That is one. Second thing is the CA Institute, they have got their own valuation standard. So the internationally accepted valuation standard, I don't know how many people will be aware of that actually.
Sir, Makhija sir, can I say something?
So it can be any,
So the valuation standards, naturally ICI has come out, maybe tomorrow ICSI may also come out with their own different valuation standards. So which standards to follow, that is another important ask. So we'll
yes, sir. That's the point. If can I say something, Makhija sir?
Yeah, please go ahead, sir.
Yeah, see, when for insolvency, that was a debtors in control regime. That time, if a valuer is appointed, you see, the people who are the appointing authority, they at least have some transparency and knowledge that, what exactly the approach the valuer should take. I mean, from a not viewing from any other angle that there is a vested interest or similar kind of a thing. The basic idea is to see some transparency in the valuation methods, and if possible, that if they have some other views or more information, they can share in such a meeting, of the valuers, so that the valuation becomes much more. It is. I mean, there is no doubt in saying that the registered valuer. Yeah, I would like to say that this kind of a meeting will not hamper anything. Rather it would bring more transparency on the subject. That is my view.
Sir, but the point is that.
Sir, this is Tanveer Alam.
Just can I just answer him? See, one thing is very important, that a valuer, when he takes up this assignment, naturally he has to consult the stakeholders. I think most of the valuers are also writing to bankers to take information and views also. So why
your voice is not much audible?
So here the valuation methodology to be explained. Now the only problem here is that to take the views is different issue. But supposing I explain that this is my valuation methodology and COC objects to that, then what happens? Because it will be recorded in the minutes then. So is it not compromising the valuer's approach? So that was what we are trying to discuss. Taking views, I think it is a responsibility of the valuer in any case also. Otherwise, how is he going to value? Naturally, he discusses with all the stakeholders, isn't it? Okay, so let's go to
Sir, can I?
Yeah, please. Yes, Manjula.
Sir, even if this is implemented, the members of COC members, how many can understand method of valuation? Many cannot understand, especially if there are operational.
Yeah, again, the problem will be, they will say, okay, today you have explained, defer it to the next meeting, we will take it back to our seniors and come back. So again, the whole methodology will
And they
get
may
into
not
it.
understand also.
Correct. I think your point is well taken. I think that's also one part of it. Okay. Any other
Sir,
contrary?
this is Tanveer Alam, sir. May I submit something?
Yeah, please go ahead, sir.
Sir, so far as the proposed amendment in 1A is concerned, that reads fine to me. The problem is with the proviso, which it has provided. So on plain reading, it seems that you have to just explain. It doesn't propose to take the inputs and the suggestions from the COC members. Now, what would happen?
No, that is all right, sir. That is all right. Please understand. We are going a step ahead. When you are explaining, somebody can object also, and if it is recorded in the minutes, then are you not supposed to record that in the minutes?
Correct.
There will be a problem.
So let me complete. I was coming to that. So what would happen if the law doesn't intend someone to give their valuable input? So this provision is to type. If the input has to come, what would happen? There would be more applications being filed before NCLT saying that this input was the methodology was not correct or rest of the thing. What would happen? It would further derail the resolution process itself. So whatever it is, it would flood the more litigation, and it would further delay the resolution process. So I think the entire provision should be deleted.
Okay. I think now we will have comments of Bhuvneshwari ma'am, then Geeta ma'am, and then Raj Kamalji. Okay, one by one, sir.
Sir, good evening to you.
Yeah, good evening. Good evening. Yes.
Yeah, my view is that, the creator, the COC members indirectly will try to find out what is the value. When we bring the valuers in front of the COC, then worried about the methodology.
Correct.
So directly or indirectly, because many times, when we appoint the valuers, the COC do not know whom I have appointed. They disclose that we have appointed 2 valuers within the timeline as per the law.
True. No, you're absolutely right, because in fact, the discussion paper also starts with that look, the value is not disclosed, and then they suddenly move on to only explaining the valuation methodology. So I do not understand. Mehta Saab, may I request you to please unmute yourself, Mr. Ritik Mehta. Thank you. Okay, I think your point is well taken, ma'am. Geeta ma'am, yes.
Yeah, good evening, sir. Sir, in fact, I also carried somewhat similar point in the sense that because at the time of lending, the values, they would have had some valuation numbers in front of them. So indirectly, they will try to see whether these people will match that value or not. Because in one of the cases, the land was at the time of lending, the valuation was very high. But then when it was in the process of CIRP, there was a right of way issue. So the valuation was completely, in contrast with what they had. So all these things will definitely crop up when the valuers are going to present their case in front of the COC, right, sir?
But ma'am, one more thing. That is all right. We understand that they should not know till the time the valuation report comes. Once the valuation report comes, then what is the stage of disclosure? Because the next point, which is the next issue, which says disclosure of fair value in the IM also, information memorandum. We'll debate it in a little while. I think let's hear from Mr. Raj Kamal Saraudi Saab.
Yeah, the existing provision is sufficient enough to handle the valuation aspect, because there are 2 valuers are giving their independent valuation, and they are giving their fair valuation. And once the fair valuation of the 2 valuers, 2 independent professionals are there, the law itself provides that if there is any wide difference, then the CRP has to appoint a 3rd valuer. And by that process, the valuation is taken fair, and the valuation comes out to be very, very fair. So unnecessary going to the COC has got no meaning. So I don't think how this provision has been thought of. Now the second issue is whether the valuation is to be shared with the COC beforehand, or it should be shared only after getting the resolution plan. Earlier, before this provision, there was earlier the valuation was shared with the COC, and the problem was faced that it is making the more problems. Now we are going back to the same things. So I think there should not be any change to the provisions of the valuation process.
Valuation. Okay. I think your point is very well explained, Raj Kamalji. In fact, this is what we were exactly discussing, that look, 2 valuers are already there, and you have raised a very pertinent point. And if there is a huge difference, say more than 25%, then a 3rd valuer is also there. So can you say that all the 3 valuers are wrong? And the COC is right in the valuation methodology. So therefore, if three valuers are coming to certain value, so therefore valuation methodology is correct to that extent. So this provision is unnecessary. Let's come to the next point, which says disclosure fair value.
Sir, sorry, I'm disturbing you.
Yeah.
Ravindra Chaturvedi here, sir.
Yes, Mr. Chaturvedi. How are you?
Yes, first class. Thank you so much,
Go
sir.
ahead, sir. Go ahead, sir. Go ahead.
I'm just talking as per the IBBI perspective here. Because of late there are many cases where the valuation was on very lower side and the backdoor entry is being observed from the promoter side. And both the valuation report, even it was done by the independent valuer, was not up to the mark. So that was the reason why this provision is being proposed. So we have to make a mechanism whereby the IBBI concern should be addressed and the unnecessary independence of the valuer should not be hampered.
No, but Mr. Chaturvedi, now let's try to understand. See how explaining a valuation methodology will bring home the point that, look, the valuation is not short charged. The point what we are trying to explain is that, look, that means if you have to disclose the value also at that stage, the values have to disclose. So here, now let's discuss the next point where it will, I think let's combine C and D together. D says disclosure of fair value in the IM now. So therefore, where the plans have not been received. But now they are saying the fair value, not the liquidation value. IBBI is proposing that the fair value must be disclosed in the information memorandum, and that is what they have proposed amendment. Pete, can you just go to point number 4 in D? Yeah. So it says, given the, just scroll up a little bit. Yeah, just stay here. So 3, it says, given the advantages associated with disclosure of the fair value with the resolution applicant, it is proposed that fair value should be made part of the information memorandum. And that is why they are amending what are the contents of the IM. So they are adding one part, it says fair value. So now, even before the receipt of the resolution plans, in fact, they want fair value to be disclosed to the resolution applicant. Do you think now, because the IBBI is saying it will improve the values of the resolution plans, so do you think it is fair enough, or do you think that it is not right to disclose fair value at this stage also?
So there are two perspectives here, sir. When we go for liquidation, in any which way we disclose the reserve price. If we disclose the fair value in EOI, the prospective resolution applicant will know that that is a benchmark, and below that I cannot submit the resolution plan. Because in my case itself, I have received 2 resolution plan and much below the liquidation value, and after due deliberation of 3 months, it has been rejected. So,
there is, Mr. Chaturvedi, there is another point. Supposing I know that fair value is 100 crores, right? And I have to bid more than fair value, I will bid only for 100.5 crores. And supposing the actual value of the company is, say, 110 crores, assuming, because see, today you are talking on the lower side, that people are giving on the lower side. But sometimes, if it's in a competitive environment like a steel industry or a cement industry where the bidders are outbidding each other, then they will also be very close to the fair value. So is it fair to disclose the fair value? That's a question what we are trying to ask. So we understood your point. I think let's have the views of the others also. Yes, Mr. Baduria.
Makhija ji, may I make a point?
Yeah, please go ahead, sir. One by one, sir.
See, resolution applicant in any case would make a value, and then only he would prepare his resolution plan. And why there is a need for this? And one more thing, if my memory is correct, the valuation should not be disclosed to the COC members was an amendment so that a sanctity is, so that any leakage of the liquidation value or the fair value in some way or the other is known to the what you call resolution applicant, and avoid any kind of a conflict of interest. If that was the amendment made, then why we are going back? That is my limited point. I don't agree with it. Yeah.
So you are saying why we are taking a U-turn, because this was the point exactly which was made by Mr. Rajkamal Saraogi also. Okay.
Yes, yes.
Yeah, I think we have
Thank you.
understood.
May I come in, sir?
Yeah, please go ahead, sir.
Yeah, I'm Pinakin, sir.
Yeah.
See, here now question is whether fair value is to be disclosed or approach is to be discussed with the COC. My experience is that normally COC also appoints their own valuer at their own cost, and they also try to determine what is the value of the going concern especially. That is the one part. Second part is that we have got three types of valuer: land and building, plant and machinery, and shares and securities. Yes, and all the three methods require different approaches. Let us say land and building, where it is a combination of cost, replacement cost plus market approach. Plant and machinery also cost and market approach. In shares and securities, there is a limited scope to explain about the method of the valuation. But what IBBI is missing, there is no enterprise value. And if there is an enterprise value, then question comes, what method you are going to adopt while working out the enterprise value. So at present, what we have got is a sum of the part method. So in sum of the part method, even though we incorporate such a provision, it is going to be a worthless provision, and it will not add any value unless and until you also incorporate the enterprise value concept in the valuation. Thanks.
Okay. I think your point is well taken. Okay. Yes, I think Mr. Adukia and Mr. Baduria, I think one by one, sir, you can unmute.
Sir, it will only, my view is also, I am KK Singla, it will only reduce the realization because a benchmark will be fixed for the resolution applicants, just like the RP fees. RP fees now benchmark to minimum fee. So similarly, the RP resolution applicant will bid only nearby, or other cartelization will also be promoted with this.
Right. Okay. I think that is the point which we made. Yes.
Sir, yes, sir. If I may add.
One by one, sir. One by one. I think let's hear Mr. Brijesh first, and then Mr. Adukia will hear.
Sir, Ashishji, thank you very much. Sir, I agree with Mr. Pinakin, sir. Number one, enterprise value concept should be introduced. It is high time, sir, because in case of corporate debtors which are operating as a going concern, the enterprise value is not captured. Number two, sir, disclosure of fair value should be there because although it is kept confidential, but my experience says it is open secret and it is known to everybody. And it is discussed also. Even COC members, sometimes new managers join as bankers representative, and sometimes they are not aware of the background. They themselves in the COC meeting disclose that this is the liquidation value. How can we accept below the liquidation value? So I think disclosure is best.
No, sir, the point is little different. See, disclosure of the value after the receipt of the plan is not prohibited. That is there. So therefore, once you are discussing the plan, naturally they are aware about the fair value and this. The only point what we are discussing is whether the fair value, if it is disclosed to the resolution applicants, will it curtail the actual value? See, enterprise value, naturally, sir, resolution applicants have got their own due diligence to value it. But if they know that, 100 crore is the value, they will, you see, put their bid just near to that. Rather than supposing their value is coming at 110 crore, but they say, okay, they are expecting only 100 crores. Why should I bid for 110 crores? I should bid only for 101 crore. The negotiation mein dekh lenge. So don't you think it will...
Sir, you are right, absolutely. But actually, this only happens. लोग शुरू अगर 100 रुपए वैल्यू कहती तो 100 रुपए से ही शुरू होगा, no doubt. बट सर कंपटीशन तो हो जाता है, प्रोसेस पे स्ट्रेस कम हो जाता है. ऑलरेडी लोगों को पता हो जाता है यार 100 रुपए से कम में ये चीज मिलेगी नहीं. Then it is a discussion.
So you are in favor of disclosing the fair value to the...
Yes, sir.
Okay,
yes.
Okay. Your point is taken, sir. Let's go to Mr. Adukia now, who has been waiting patiently.
Good evening, sir. Thank you for the opportunity. Sir, in my view, the board has to come out with a clear understanding whether they want to disclose the value in advance or not. If you see the suggestions earlier, they said you go to the COC, get the methodology vetted, but don't share the value. And in this clause, they're saying you share the fair value. Everybody in the industry knows what is the ratio of fair value and liquidation value that the liquidators use, the valuers use. Anybody, what this solve will be able to tell this is the liquidation value, this is the figures that are coming out. So if you want to disclose, please do it. Remove that amendment which was done, that it will be disclosed only after the plan is submitted and you let it be a part of IM. One. Secondly, the timelines. When you appoint the valuer, it is only 37th day or 47th day, depending on whether the IRP is confirmed or not. And the IM has to be given in a particular time frame. By that time, it is not possible to get the valuation report done.
No, I think your points are well taken. I think we were discussing. So what you are trying to say is a step forward, that if fair value is disclosed, naturally liquidation value is also disclosed to a larger extent.
Yes, sir, we all know how that is calculated. Everybody in the industry knows that. I mean,
Correct.
It's not some rocket science. It is, everybody.
20% का margin ले लिया, किसी ने 15% ले लिया, तो liquidation value उतनी होगी. I get your point, sir. Okay. Yes, Parag.
Sir, good evening. Sir, please tell, in current regime, is COC not authorized or not empowered to call valuer in COC meeting in case they need any clarification on the methodology used by them? Why this amendment is required?
I'll tell you, Parag. The system is like this because valuation report comes. Valuation report is not shared with the COC before the receipt of the resolution plans.
Right.
Once the valuation report is already there, it is opened, or it is made known to them the liquidation value and other things. Then even if they object, it doesn't make any difference because the valuation reports are already there. They're not going to be changed at that stage. So it is not discussed or debated as such.
I agree, sir, bilkul. But what I'm saying is not COC authorized to, after appointment of valuer, can't they call valuer for discussion in the COC meeting for methodology only? And presentation.
I see there is no provision as such because the provision only says 35(2) very clearly says that look, you have to disclose only the values. That's all. So methodology or not, that is not there. But naturally, those values can be shared with them.
Right.
That is okay. I think we
Actually,
have Mr. Pandey. Yeah, please go ahead. Sir.
Hello. What is it? Hello.
Mr. Patwal, you're trying to speak here.
Yes. Sir, actually, everything
can you just hang on? Can you just hang on for a second, sir? I think Mr. Sanjeev Pandey has been waiting very patiently. I will come back to you, sir. Okay. Yes, Mr. Pandey, I think you need to unmute yourself, sir. Yes.
Yeah. Good evening, sir. So, yeah, actually, this suggestion, I remember we made this suggestion from SBI to the IBBI. We had a meeting there. So this suggestion, I think one of the maybe recommenders for us. And the idea behind this were two. One is, of course, as Mr. Pinaki shared, most of the RAs know the value of liquidation value already, even with the non-disclosure clause already in the law. So this creates a kind of asymmetry of information. Some people know the liquidation value, some people don't know. Who knows the value has an advantage. So we said that why don't share it, make it open, because it's not giving you any advantage or any advantage to the COC. Second idea was that in many cases, when at the time of resolution plan discussed in the COC, now that value came out, and we were really surprised as banks, how come this value has come? Because it is nowhere near what valuation we have in the bank's books. We also do valuation every year. So it was, and then sometimes it is too high. We also know this cannot be, this valuation is not reasonable, because some land is valued too high or machine is valued too high, or sometimes it is too low. So unless it is discussed and the methodology is discussed in the COC upfront, sitting in front of the valuer, so we recommended that why not keep it open and let the valuer come and justify his valuation before, let COC question him before finalizing the valuation, so that some reasonable value comes out. It will not create problems for COC in approving the plan. Also, like connecting their valuation in their books and the valuation now. So there are so many things. So I think that is the idea. The value should be open, and I am in favor of this disclosure.
Okay. So in a way, the whole idea is to influence the valuer in reaching a liquidation value.
No, not influence.
No. I think Mr. Pandey, let me discuss this. I think he has raised a valid point. Obviously, we'll have to look at the banker's perspective. Just a sec, sir. Just as I'll come back to you, sir. What Mr. Pandey is saying is, keep it open. I mean, he says, let's not keep anything under the wraps. Today, we are keeping everything under the wraps. We are disclosing the fair value and liquidation value only after receipt of the plans. That's all. And now we are somewhere in between. We are not disclosing fully. We are only disclosing the valuation methodology and also disclosing the fair value to the resolution applicant. His suggestion, as I have understood from Mr. Pandey, is let it be open. Let the when the valuation is being done, when the draft report comes, probably the draft report can be debated and discussed in the COC. And if the bankers have got a different valuation or a valuation report, that can also be shared with him. And then probably he'll take that into consideration. And then probably a value will come. It's not that COC wants only their value. The idea, see, let's not start putting blames on the bankers and other thing. Obviously, they also want the better value, isn't it? I think that's because they want to recover more.
Yeah,
so that's the idea which is there.
One more thing, sir, I'll say.
I'm surprised, Ashish ji, but how can the valuation given by valuer can affect the recovery? I give a valuation of 100 crore rupees. Let them not approve the plan. Let them discuss the plan with the SRH. How does it impact the recovery?
Okay, so Mr. Sharma,
It doesn't. It's a sheer attempt to influence the evaluation methodology. That's it.
Mr. Sharma, what you are saying?
The COC wants to be master of everything.
No, just hang on.
Even I feel that this is something.
Mr. Sharma, Rekha ji, just hang on for a second.
Yeah, sorry.
So, Mr. Sharma, what you are saying is that look, the negotiation part takes care of what you are trying to say. So it takes care of the values because the negotiation is definitely can happen, right? That's what you are trying to say.
Exactly, sir. Exactly.
But in fact, you see, according to me, if I disclose a fair value, well, then the negotiation will also be limited, isn't it?
Don't disclose even fair value.
Okay, I think that's also a valid point. Let's hear from Rekha ji and other members, and then we'll
Ashish ji, it's only one point that how somebody can encroach the area of expertise. I mean, tomorrow somebody would say how you have calculated the income tax, before you get it approved from me, how much tax I'm going to pay.
We'll put this question
there are too many things to talk about. I mean, it's like, you are literally encroaching somebody who's expert, and the person who is not at all expert, he wants to say that, oh, I'm expert in everything.
The
person who can't even take a decision in the COC and being all or harassed broadly by the COC members, they want to encroach all the areas. How it is possible?
Okay, let me barge in here.
No, I think Makhija sir, as Mr.
So I think let me barge for a moment right now. Saying that look, they are the experts. 2 experts are already there. Now, if we are questioning the methodology, we are questioning the experts. Mr. Pandey is trying to put a point that they also took a evaluation report and probably from an expert only, naturally from expert only. So if there are difference of opinion of 2 experts, naturally the COC should be able to debate and discuss. They are not trying to influence. They are trying to understand that why this valuation is now lower than what they have got it. Probably their report may be wrong.
For which we have already the provision to appoint the third valuer.
For that, they have to go back to their valuers and not CIRP valuer. Let them go and ask their valuer why the report is different.
And we have already the provision for appointing third valuer.
If there's a difference between their value and the value under CIRP, they should choose their valuer and not independent.
How do we expect that the intimidation will not happen? That happens in India, and everybody knows that.
May I share one more instance here?
Yeah. I think Mr. Pandey, now you'll have to just very briefly counter these things. Yeah.
First of all, I have a disclaimer to make that I am no more a banker. I am a retired person. I am an insolvency professional now.
Everybody knows, sir. Everybody knows it.
Yes. Second thing is that there are like situations where the valuation was too bad. It led to liquidation actually, because the value was kept so high and so unreasonable. Then COC said that nobody will come at this value, and ultimately it led to liquidation. Third thing is there are instances I have seen during my career in the bank, even outside the bank also, the RPs are approaching the valuers because I want this value. If you are ready to give, I keep you as a valuer. So these instances are also happening. I'm not saying it very prevalent, but there are few instances like this where RPs demanding a valuation from valuer. You give me this value, I give you the job. So those kind of things, why not keep it open and let the professional.
Exceptions are always there in all the fields. For all the exceptions, we can't have rules.
No, let me complete. So finally, I said that let it be an open process, transparent process, and we are not influencing because COC minutes are minuted. Whatever everybody says is minuted, so nobody can influence. And second thing is why let the expert explain his methodology. Let him come and explain why he has given this value. So that is the only thing we are asking.
Okay, I understood. I think we have understood the point. Let's hear the views of other. I think Mr. Ravi Chandran is there, Mr. Sharma is there, and yeah, Dr. Vichitra Narayan. So I'll one by one, sir.
Most of the enterprise value.
Good evening, sir. Good evening, sir. I'm Pathak.
Just
Good evening,
one by
sir.
one. So
I'm
let Mr. Ravi Chandran conclude, and then you can come in, sir.
Okay, okay, sir. Okay, sir.
As we are aware, most of the enterprise value come with a lot of disclaimers because the accounts are very old and the data is very old. So they come with a lot of disclaimers. So suppose we give the value as stated in the valuation report, who is going to own these values? That's the first question actually. Because these disclaimers, no one knows whether subject to this, what will be the exact value.
No, what you are trying to say, sir? I mean,
I'm saying that, the fair
elaborate your
value.
point? No, we understand there are certain disclaimers, but what is your point, sir? Can you
The
elaborate?
fair value can change, sir, because of the disclaimers. The fair value, who can decide that what will be the exact fair value? It may be higher or it may be very low.
This is exactly where Mr. Pandey is coming from. That look, if you have included 10 disclaimers, please explain it to us. So we can correct you that look, this disclaimer is not right. And we have the information, you have the information, because our other valuer had that information. This is exactly what he's saying. Let it be transparent. I mean, what is the harm in it? They are not encroaching on the authority. They are not saying that valuer should not give that report. They are simply saying, come and explain it to us. After that, it is your wish. Whatever report you want to give, you give. This is exactly what his point was, which I understood. I don't know whether it is or not.
Then fine, sir. Let him explain in the COC. That's it.
Okay. Yes.
That's
Okay.
it. Yeah.
Yes, Dr. Vichitra Narayan. Sir, please go ahead, sir.
Yes, sir. Good evening, sir. Thank you, sir. There are only, this question is always raised by the financial creditors. Even in Mumbai chairman's meeting, also they are telling your valuation is lower, this and that. So there are two kind of the valuation is there. One is the valuation done by the valuers appointed by the IBBI, and there are guidelines are there. And second is the valuation done by the COC member, because most of the financial creditors are also having the updated valuation report. Then why this question is coming? Because this question is coming. Bank's valuation is also lower. Our valuation is also lower. But when they are pleading to their top management that valuation by the IBBI is lower, sir, what we can do? So naturally the management is having question. So when there are two valuation. If valuation of the financial creditor and valuation by the valuer by the IBBI, this should be interacted and to reach the conclusion. In my opinion, there is not much difference. Only this is a question of saving exercises are being done. And third thing, in my personal opinion, RS should not be disclosed to the valuation report in the IM, because they will prejudice them about the valuation, their own valuation report, because they are the purchaser. So there is a one report for taking decision, reconciliation of COC members and the valuers by the IBBI. And second, what is the assessment of the resolution applicant? If ours are lower and resolution applicants are going better valuation, then COC member have the best voting. Okay. If they are not matching, naturally they will not get the votes. But resolution applicant should not be given in IM in advance.
We have understood that look, it will impact their own independent valuation. So supposing their independent valuation is coming more, they will subdue the value in the resolution plan also. I think that point is well taken. Yes, I think
sure,
Mr.
Sir.
Sharma.
Thank you, sir. Thank you, sir. So nice, sir.
Thank you, sir. Hello.
Yeah, I think Mr. Sharma wants to speak, and then we'll. Sharma ji, mute.
Sir, I would request not to ignore Mr. Pandey's remarks, because they are kind of independent remarks, and he is trying to bring out a position where the companies which could have been saved were forced into liquidation. But at the same time, there is one issue that COC itself is entitled to bid. So we cannot overlook this part, that a COC member himself can also bid. So I think a midway disclosure can be thought, looking at what Mr. Pandey has suggested. So I think before we conclude,
Yeah, Sharmaji, your point is well taken. In fact, this is a point which he has brought in, and which goes against disclosing the fair value or other valuation reports discussion. Because COC members, he's absolutely right. The financial creditors who are sitting on the COC, they can also make a resolution plan. Now, if they are aware of the valuation methodology, so they are aware of better things than other resolution applicants. So now there is a kind of asymmetry. So for that, Mr. Pandey says, keep it open, make it transparent, but still the valuation methodology and disclosure of the valuation report has to be then disclosed to every resolution applicant. But then there is another issue that, look, if we disclose everything, then resolution applicants will not do their due diligence. They will simply rely on this and then try to put the resolution plans in accordance with this, which may subdue the entire value. So therefore, people are saying that, objecting to that, look, fair value should not be disclosed to this. I think we are fairly covered. If any quick comment is there, we can take those comment and then let's move forward.
Sir?
Excellent, sir.
Yeah.
Hello?
Yes, Mr. Anil Singh,
Hello?
please share your comments.
Sir, my question is that when the valuer is giving his report to the RP, he mentioned everything in that report, what is the methodology and how he arrived in this value. And in regulation of IVP, it is also mentioned what is the how you will do the valuation. It is a fair value and liquidation value both. Okay. And second thing is that everything is mentioned in the report. So why he is asking for that report? What is the methodology? That means they are not reading the report properly.
Okay,
And
so
when the
in any
valuer
case,
is going
so
for the
therefore,
valuation, so he will get a very low data from the RP, because in most of the cases you will not get the data, proper data. So how you will do that? Question is that.
No, see, the point is not that. See, let's not get into how he's going to value. The point, what we are trying to say is that a valuer is independent and expert. Let's not put a question mark on him. And if he does some mischief, if he does a wrong valuation, then regulators are there to take him to the task. Anyone can object to that and then take it to IBBI. So I think that's fair enough. So let's not subdue the whole discussion on this. So I think we are concluded that, look, fair value is being objected to be disclosed because ultimately it may subdue the entire resolution plan value, because negotiation takes care of it. So supposing tomorrow a resolution plan comes for say 90 crores, where my fair market value is 100 crores, naturally COC will discuss and they have a right to reject. So therefore, negotiation takes care of this undervaluation or whatever those things are there. Okay, I think let's move forward now. Continuation of the process activities pending disposal of extension application by the adjudicating authority. I think this is something which is very, very procedural. I don't think this requires too much of a discussion. What they're trying to say is, Peer, can you just straight away go to the proposal and also the amendment? Yeah. So it says, in order to bring clarity on the continuation of the process when the application filed with A is pending for the extension orders, and to enable the RP to fulfill his responsibility, amendment to regulation 40 is proposed. So what they're saying is that it is clarified. So they're just only adding a clarification. It is clarified that the RP shall continue to discharge his responsibilities under the CIRP for the period when the application seeking extension of the CIRP process is filed by the RP, till the application for extension is decided by the adjudicating authority. I think it's more procedural. I don't think anyone should have. If anyone
insert
has,
one word, exclusion also.
Sorry?
Insert extension oblique exclusion.
No, but they are, no, sir, that cannot be put in because they are putting this clarification under section 12. Section 12 only talks about extension. Exclusion is a power which is not within the law, but it has come from the case laws, isn't it? So therefore, they have put in only extension. So I don't think anyone is going to have an objection to this. So if anyone has a different view, then I think we'd like to hear from them. Okay, I believe everyone agrees to this. Okay, last one, clarity in minimum entitlement to dissenting financial creditors. Now, here is something which is very, very controversial out here. I think we need to devote our time here. Number one, let me explain this so that I think everyone is on the same page. Section 32B, I think most of us are aware that guarantees the minimum payment, A, to the OCs and B, to the dissenting financial creditor. Rather, I will not use the word dissenting. I will say the financial creditors who have not voted in favor of the resolution plan. This is exactly the word. And in fact, this is the last sentence. So they are not talking about the minimum guarantee to the OCs. They are only dealing with the minimum amount to be paid to the dissenting. They have used the word dissenting. So let's use that word, dissenting financial creditors. So what the current provision says, which and provides for payment of debts to the financial creditors who do not vote in favor of the resolution plan in such manner as may be specified by the board. Underline these words, friends. In such manner as may be specified by the board, because I'm going to discuss on this. Which shall not be less than the amount to be paid to such creditors in accordance with subsection 1 of section 53 in the event of liquidation of the corporate debtor. So what they are trying to say is that, look, the realizable value is not known at this stage. So what is to be distributed under 53(1) is the liquidation value. And they say that, look, the liquidation value is calculated on the insolvency commencement date. And supposing 4 years have gone by or 3 years have gone by, naturally the value must have depreciated, the liquidation value. But still the dissenting financial creditor gets an advantage because the value which is calculated on ICD, now he gets the share in that only because that needs to be distributed in accordance with 53(1). This is what the problem statement, what they say. Now, what is the proposal? Pete, can you just go a little above? So go to the proposal part straight away. Point number 10. Para 10. Yeah. So this is the proposal. No, just go above. Yes. In view of the foregoing discussion, the following is proposed. Let's try to understand this because this is a little complicated, and I believe, and I'll explain it to you, to provide clarity with regard to entitlement of dissenting financial creditor, which shall be lower of. Remember this, friends, which shall be lower of. What they are trying to do, trying to say, amount that would have been paid to such creditors if the amount to be distributed under the resolution plan had been distributed in accordance with the order of priority in subsection 1 of 53, or liquidation value as defined under these regulations being distributed in accordance with order of priority in subsection 1 of 53. So now they are saying they are giving a disadvantage to the dissenting creditors. And in fact, this disadvantage will actually is against the provisions of law. I'll try to explain. So what they are trying to do is, earlier, they were entitled for a minimum amount of liquidation value distributed in accordance with 53(1). Now they are saying it will be lower off. Lower off, what is the amount to be distributed in the resolution plan if that was distributed in accordance with 53(1), or what is distributed or the liquidation value which is distributed. Now, why I'm saying that this is objectionable and this does not stand the scrutiny of law, there are 2-3 points which I would like to make, and then I'll ask for the comments. Number one, if you look for operational creditors, similar provision is there. What is the amount proposed in the plan? Resolution plan value distributed in accordance with 53, or the liquidation value if distributed in accordance with 53, higher of that. It says higher of that. So if it is higher for operational creditors, we are trying to make it lower for the financial creditors. So this is one dichotomy which I'm finding in the act, number one. Number two, let's look at section 32B once again. Peer, can you just go above? I think just go to the first part where the 32B was noted, para 1, point number, yeah, this one. Look at this. It says, and provides for the payment of the financial creditors who do not vote in favor of resolution plan in such manner as may be specified by the board, which shall not be less than. The law says, 32B says it can't be lower of the liquidation value. Today, IBBI is trying to make through a regulation, a proposed regulation, lower of liquidation value or the resolution plan value. So friends, according to me, this will not stand the scrutiny of the you can say the law itself. Because according to me, this provision is bad. To that extent, if challenged in any court, it will create problems. So here they are trying to do that. And the second point, what they're trying to do is, it says that if to dissenting financial creditors, the payment should be made in priority to the other creditors, right? The word is in priority. So some people have interpreted in the sense that, look, if I am a dissenting financial creditor, if I'm entitled for 2 crore rupees, it should be paid first to me before making any payment to any other financial creditor. So other financial creditors objected, is that what is this? Just being by dissenting, you need not be paid first. So what they are trying to do is, they have put a small table. Pete, can you just scroll up? You see, go to the next page. No, go to the next page. No, go to the next page. The amendments page. Yeah, there is a table which they have given. Look at this table. So here, what they're trying to say is that it should be paid pro rata. Like supposing if the financial creditor is paid 50% today, the dissenting creditor will also be paid 50% today. If 30% is paid in phase 2, say after 3 months, then 30% will also be paid to the dissenting financial creditor at that time. So they are trying to make parity between the financial creditors and the dissenting financial creditors, assenting and dissenting. So probably they are trying to do that. So these two things are there. Pete, can you just show the proposed amendment, para 11? So keep it on the screen and then we'll start debating. So look at this. What they are trying to do is, because they can only specify the manner, isn't it what we saw in 32B? So what they're trying to do, IBBI, is now they're trying to insert a new definition now. And look at this definition. They say amount due in the event of liquidation shall mean lower of amount that were due and paid to such creditor if the amount to be distributed under the resolution plan had been distributed in accordance with order of priority under 53(1) or the LV if distributed in accordance with 53. So now they are trying to make it lower of resolution plan value or liquidation value rather than. So now there is no incentive. If this provision comes, friends, please remember, there will not be any incentive for any creditor to be a dissenting creditor. This is my view. Let's have a discussion on this. If you have read it very carefully, so let's have a discussion on this. Any comments? Yes, Manish ji.
I think what point I want to raise, you already covered. The IBBI is only empowered to decide the manner of distribution. They are not empowered to decide on the amount of distribution. So through this regulation, what they are trying to do, they are trying to decide the amount of distribution. So in a way, is again overstepping on the delegated legislation. That has been in the habit of IBBI for many years now.
Okay. And number two, not only that overstepping, see, other point is, look at this. For operational creditor, it is the higher off. Look at, and today for dissenting financial creditor, we are making it as a lower off. So you are between two categories, you are making a differentiation.
You can't make it either higher off or lower off. You are only empowered to decide the manner and not the amount. Amount is decided by the parliament. That's it.
Assuming yes, absolutely, sir. I think it is.
Let's just, Mr. Kabir, just hold on for a second.
Yeah, sure.
Assuming they are empowered, let's take for a fact. All I'm saying is, even if it is allowed, then for operational creditor, it is higher of both the limits. And in case of dissenting financial, it becomes lower. So don't you think it looks unjustified on the face of it also? It is a discrimination.
To me, that is not unjustified. For different classes can be treated differently. That's fine. My basic objection is on the delegated legislation and overstepping that. That's my observation. That's my submission.
No. So there is another thing. Why I've said that it is discrimination, because look, the law says only it should not be less than the value of the liquidation. Today you are making it as lower of this thing, because you see, protection is given not for the lower. Protection is always given for the higher amount.
Oh, absolutely.
There is no protection at all. That's what I'm saying.
Exactly, okay, sir. Exactly, sir. Absolutely.
Yes, sir. You want to
make? I think there are two. Yeah. Both the aspects.
Sir, does it mean that the regulator does not want a dissenting vote in general? They say, please put the resolution through. Does that mean that regulator, knowing all this well, wants to avoid dissenting?
I'll tell you, sir, what is going to happen. Let's understand. Now, in a resolution plan, because majority can definitely, you see, what amount to be distributed, how the manner of distribution can also be taken by the majority of the COC, isn't it? Now, the majority of COC, in order to say curtail the rights or oppress the minority, now they may say, okay, pay them only 10 crores. Though their security interest, see, it should be linked with the security interest, according to me, because their security interest may be 30 crores, but in the plan, you are only paying them only 10 crores. And then you say it is lower of the liquidation value or the resolution plan value. Now, what is the purpose of this? So one is overstepping. That is the point which we have already debated and discussed. Two, it also looks unfair on the face of it. This is what we are trying to understand this. Yes, any other contrary views, sir? Mr. Pandey?
Yes, sir. So our view, as we have experienced in some of the COCs, what happens, there is a matter of strategic dissent here. So some of the banks, they strategically dissent because they get an advantage, especially where the resolution plan value is lower than the liquidation value. So that is the place where this problem occurs. So many of these private sector banks, some of the public sector banks, they have this strategy. Wherever liquidation value is higher and plan is coming lower, so if we both dissent, so we'll get minimum liquidation value.
But then, Mr. Pandey, if I take that point strategy, that is in democracy, everyone is entitled to take their own call, whether it is strategic or whether non-strategic. Number one. Number two, sir. Here, if you are incentivizing, then there will never be a dissent now. No, so you are taking dissent out of
only the
let me पांडे साहब का कहना है स्ट्रेटेजी इसलिए भी है कि अगर आपकी सिक्योरिटी कवर ज्यादा है तो आप अपने सिक्योरिटी कवर के ऊपर प्ले करोगे ना
तो ठीक है ना सर उससे फर्क क्या पड़ रहा है देखिए आज अगर सपोज आई एम 34% आई एम एंटाइटल्ड टू डिसेंट वेदर स्ट्रेटेजिकली ऑब्वियसली आई विल टेक अ कॉन्शियस कॉल You are taking a conscious call as a 66% to approve the plan even below the liquidation value. I've got my right to protect myself.
No, I'll give you examples, sir.
Because otherwise, sir, क्या होगा? Otherwise, देखिए सर, मैं एक चीज और देखता हूँ. सर, आप देखिए. Otherwise, 66% will always bulldoze 34%. हर सारे plan below the resolution.
Their right to dissent is not being challenged. Only thing, they will not dissent just because they are getting some monetary advantage because of this. So that element.
If they are not getting any advantage, then they will never dissent, sir.
No, they can always dissent because not just based on the because
सर अगर उनको रेजोल्यूशन प्लान के हिसाब से ही पैसा मिलना है तो फिर तो डिसेंट का कोई मीनिंग नहीं रह गया ना सर आप प्लीज अंडरस्टैंड दिस
इसी में सर इसलिए हो रहा है क्योंकि then the assenters are being penalized that they are approving a plan because ultimately under the law always plan gets more value than liquidation. That is the general understanding. That is the experience of last 7 years. Wherever company goes into liquidation, we are put at a loss. Resolution brings more money on the table. That is one.
Therefore, the dissenters will not get advantage of this provision. Then, so that's all right then. So basically, देखिए dichotomy क्या हो रही है सर यहाँ पे देखिए सर if you are approving the plan much beyond the fair market value or liquidation value over the liquidation value, then dissenters cannot take advantage of this 32B. The advantage is only when you are proposing a lower value than liquidation value, then they say, look, minimum guarantee has to be given to them because this was NLV. Otherwise, they could have said, had they been in majority, they would have said, let the company go to liquidation. I would have realized that my money better.
But then in that matter, what will happen is even the assenters will tend to dissent. No, so they will take it to liquidation then. They say, okay, we'll also take it to liquidation. Everybody will then.
No, sir. देखिए, sir, in last 6 years, that has not happened.
No, it has happened, sir. There was a matter, I remember there was a matter admitted in 17, plan came in 21. Value went down by almost 200 crores. So against the 600 crore liquidation value, plan came for 450 crores. And ICICI Bank, Canara Bank, 3 banks dissented just because they were getting a payment on the basis of 600 crore valuation, which was 4 years old.
Sir, the problem is not with the discussion in the meeting. The problem is the time. So let's not take advantage of that. There is a delay. Therefore, we should put this provision. I think we are short-sighted. According to me, sir, we are short-sighted. Because dissent करना मेरा एक right है सर. Dissent आने दो ना. आप फिर भी bulldoze तो कर ही रहे हो ना उनको. 66% से approve होने दो. उसमें क्या problem है?
Makhija sir, both the points you said are bad in law actually. That is a very, very important point which you highlighted. Both the provisions, this dissenting part as well as that minimum this thing, they are the lower of this, both are bad, and it cannot be, legislation cannot be like that.
If the government wants to bring this point, I think they need to amend the law rather than bringing through.
Exactly, sir. Then the substantive law, that is the IBC code, must be changed.
I agree, sir.
Because you are just fiddling with the 53 distribution, which is based on certain natural justice and fairness. You can't change it through a regulation like this.
Yeah.
Then you are just touching substantive law from where you derive all your procedural laws right. It cannot just be ultra vires.
Understood, sir. Understood. I think we have already debated.
Thank you, sir.
We'll put that point that IBBI is over.
Yes, sir. Yes.
So
please, sir.
Yes, Mr. Tanveer Alam, do you want to say something?
Yes, sir. Yes, sir. Just for record purpose, as you rightly said, that the IBC says something which is to protect the interest of the minority financial creditor who dissents from the majority who approves the resolution plan. So that talks of the higher value, and this amendment talks of the lower value. So this is a clear contradiction, and in case of contradiction, that the provisions IBC wishes to. You have rightly said this, and I think most of our members have said this. Just I'm saying this just for record purpose, so that the voice goes to the IBBI.
Okay. Achha, now the second point where they say parity in payment, I mean the installment payment. I think, do you agree, or do you still say that they should be paid in priority first and then the other assenting financial creditors, or there should be a parity in as far as payment is concerned?
No,
I think
they
parity.
They are converting here.
There has to be parity, but in the manner of the priority which Section 30 prescribes.
That's all right. Even regulation that does not prescribe. Regulations prescribe. Regulations prescribe that there should be a priority in provision. So what today the IBBI is trying to do is they are trying to bring in changes in 38(1)(b). Pete, can you just scroll up a little bit? Show that next regulation. No. Go down. 11.2. Yeah. Okay. So no. Just stay at 11.2, please. So here they are adding clarification. Just stop here. Clarification. It is clarified that at no stage of implementation of the resolution plan, financial creditors who voted in favor of the resolution plan shall be paid a higher percentage of dues than the financial creditors who did not favor the resolution plan. So they are trying to make parity between assenting and dissenting. I don't think we should have any objections here, because supposing the money is, say, only 50 crore available in the first phase, which has come in the first year, supposing the RA is bringing in first 6 months, then it should be distributed on a pro rata basis. So I think this is fair. I mean, to that extent, I don't think, but the language of the table which they have given is little confusing. I mean, I could not really understand it. I have to read it 4 times to really understand this. Anyhow,
they have converted
more easier to understand.
They have converted priority to parity, basically. So
Priority.
there is no more priority now. It's a parity now.
No. Correct. So why there is a dichotomy? I think Mr. Munish is right, because if you read other provisions, the other provisions have not been changed. The other provision still says that they should be paid in priority. So I think we need to reconcile all the provisions. So if we have to change it, then we have to change all places. Otherwise, there will be a confusion which will be there. I hope, sir, we are all on the same page on this. And
Yes,
the contrary views of Mr. Pandey will also there. We will definitely take into account. And see, there is one more thing. This illustration, Mr. Munish, let me ask you this question. How will you implement this in case of real estate? Let me give you an example. Supposing there are real estate case, 99% are home buyers. 1% is only one dissenting financial creditor, say one bank. Now, home buyers do not get the money, they get the flats. Typically, they get the flats, isn't it?
Yes,
now,
yes.
here you are saying parity, that if you get on the 50% of the entitlement, you should be paid. Now, home buyers are getting flats. How can you compare flats with the money? So I think in real estate matters, this illustration is totally useless.
Obviously, in real estate, you cannot implement it. There's a totally different ballgame.
Correct. So I think this will create confusion in case of real estate matters. So we must
yes.
notice. Okay. I think we have fairly discussed all the points here. Friends, one last point is there, which talks about G, mandatory contents of the resolution plan. Friends, we have been continuing for 2 hours. and we have not even covered the first one. So I will take a call. I mean, we'll have to take a call whether we want to continue, because for real estate, again, it may take 1 more hour. So we'll talk about that, but let's concentrate on this first. Mandatory contents of the resolution plan. So what is the proposal? Can you just go above? Yeah. Just go to the, so now they are saying the how the money will be distributed to the stakeholders should also be included in the resolution plan. So now they are dividing the resolution plan into 2 parts. Part A, which will contain this information. Can you just scroll up a little bit? Selection of the resolution applicant, background, feasibility, approvals required, means of finance, amounts to be paid, and total proceeds of the resolution applicant. That means the total realizable value. And then means for implementation, including the escrow arrangement, will be a part of Part B. So that will be in Part B. And Part B will deal with the payments to be made to each category of creditor. So how much is to be paid to the creditor? So now resolution applicant is deciding that who is going to be getting how much of their admitted claims. So this is one thing. Can we just go to the proposed amendment? Just scroll it. Yeah. So this is the proposed amendment, Part A, which we have read. Yes, just go below. Scroll it. And then Part B comes. This is Part A, and then Part B shall provide for, look at B, the payments to be made to each category of creditor and other stakeholders again. So they have practically reworded the entire Regulation 38. So that is what here the meaning is. So any questions on this or any comments on this? Or do we think that it is all right?
So this is a proposition by the RA that this is how the money should be distributed from my escrow.
Correct. So is it okay, or what? I mean, are we okay with this, or we are kind of any comments on this? Yes, Munish.
It is okay. It seems okay, sir.
I have few doubts. How will it work in the real life scenario? Now they say when it goes to approval, the AA will first approve Part A of the plan. So now AA now required to approve at 2 stages. Part A separately and Part B separately, because they say that litigation is always on the Part B, not on the Part A. So Part A will be approved. The inflow can commence. RA will take over the CD. The Part B dispute, if any, will continue.
Okay.
Now,
okay, let me explain, sir, to all the participants first. Peer, can you go to the next page? What Mr. Munish is talking is coming from the proviso. Now, here it says, provided that the committee shall recommend whether a resolution plan prepared in terms of clauses 1 and 2 shall have the provisions of separate approval of Part A and Part B by the adjudicating authority. So it is not that in every case it is going to be a separate approval. It is on the recommendation of the COC whether Part A should be approved or Part B. But yes, I agree with you to a larger extent. Number one, who is COC to recommend like this? It has to be a legal provision, because our legal provision says the resolution plan is one. It can't be approved in parts. So Part A is approved today and Part B is approved later. I don't think it can come through regulations. It has to come through the law. So that is section 31 needs to be amended. That is what my view is. Number one.
Yes.
But COC cannot override any legal provision. Who are they to say?
That's where I was coming to exactly.
Yeah. You are absolutely right. I think we have an objection to proviso. But besides the proviso, sir, do you think the other parts are okay?
Yes, there is again problem. Let us say there is a case where the once say 31 is amended. Let us say we have Part A approval and Part B approval. Part A is approved. I am an SRA. I have put in 100 CR, taken over the CD, and Part B is not finally approved.
Right.
What happens to my plan?
Right. Absolutely. Or it is amended with some modification which is not acceptable to me.
Yes.
So that could also
amended with modification. Another thing, let us say I am an FC. I have approved the plan.
But sir, in this case,
I don't want to cede the control of the CD unless I start getting some inflows.
Why sir, if you remove the proviso, then
if we remove the proviso, then that will take care of everything.
The question does not arise now. Plan will be approved fully. And I don't think even in real estate cases, there is going to be an issue. If you go to part B, and if this amendment is carried out under the law, will there be a problem in real estate cases?
Okay, part B, can you show part B? Just go to the previous page.
The only protection we have to take is for real estate if this law changes.
Peer, can you hear me? Can you just scroll one page above? Okay, I think either the screen is stuck. Anyway, so the point what we have tried to say is that, look, here what the IBBI is proposing is that the distribution should also be included in the plan. Now, here comes one problem. The plan can be modified only once. This is a new provision which has come. Now, supposing the majority of the creditors are not satisfied with the distribution mechanism, they will naturally make the changes. They will say, sorry, we are not agreeing with this distribution mechanism, change it. But can it be changed only once? Because naturally the modification can only take place once only. So I think this is becoming little restrictive to that extent. So first we are giving an option to the RA to distribute money, and he does not know who is going to dissent. So therefore, what is the money which is going to dissenting creditors? He does not know that. So these are few important aspects which are there. So naturally, I think some precautions need to be taken into this. So we will have those comments. Any other specific comments on this, sir, which we would like to include here?
Sir, go ahead to the next real estate part. I don't think
Sharmaji, that is what I was trying to discuss. Look, today we are already very late now. Peer, can you hear me? Can you unshare this document right now?
Yes, sir.
Okay, can you unshare this document? So that
Unshare?
Stop sharing.
Stop sharing.
Okay, sure.
आजकल इंग्लिश बहुत चेंज हो गई है. Okay. Acha, now friends, I think we have already consumed more than 2 hours here. Real estate may, again, I think it's going to take almost 1 hour. So I don't want to encroach this thing. So I'm just suggesting, let Peer also take a call. Peer, can we have this discussion? What is the time frame? I think उसमें तो अभी time है ना शायद comments के लिए.
Yes, sir. It's last date is 28th.
28th. So I think can we have another session separately on this rather than doing it today? Because
yes.
You mean 20?
It's already very tiring now.
Yes, sir.
Sir, that would be great.
Yes, sir.
Shift it to another session.
Yes, sir.
Yes. Because then we will be coming with a fresh mind and then debating on that.
Correct, sir. Correct.
So, Peer, I think most of the participants are requesting for another session. We can plan it out. Is that okay?
Yes.
Yes.
Great. Okay. So
Yes,
thank
sir.
you, I think, for patiently, listening to me and then contributing in a big manner. I think this program becomes successful only once you contribute. And I can see many stalwarts out here with smiling faces even after 2 hours. I think I must.
Sir, I left cricket match for you.
अच्छा ये प्रोग्राम उसी टाइम रखना जब वर्ल्ड कप फाइनल ना हुआ.
वो जरा देख लेना मैडम.
आपका deliberation था.
Tentative date कर रख सकते हैं अभी, tentative date and time because of your time zone.
I think we'll do that, sir. वो अभी 28 से पहले कभी भी एक बार बीच में रख लेंगे, sir. I think we'll do that. Okay. So thank you, and I think over to Peer for her closing comments.
Sure, sir. Sure. So, sir, we'll postpone the other half of this discussion, and we'll let you all know as per the availability of Makhija sir about the next part of this session. So, I just before concluding, I just want to thank all our participants for participating over this online discussion and becoming part of interaction, and also like to extend my thank to our eminent speaker Ashish Makhija sir for kindly agreeing and to deliver.
I'm only a part of the fraternity. I'm just like them. I'm not eminent. I'm only a part of them. And I think this session becomes successful because of their participation.
You are being modest, Ashish ji.
So thank you so much, friends. I think we will see you next time. We'll announce that program, and please do come. Thank you so much.
Thank you, sir. Thank you, sir, so much.
Thank you, sir.
Thank you.
Excellent session it was.
Thank you.